Well, back in colonial America, there was a problem. Actually, there were many problems, but in this video we'll concentrate only on one of them. And it was a problem that the Seventh Amendment tried to fix. So, let's say you're in a business and a British customs officer claimed that you owed him £20 in import duties. Well, money you insisted that you had already paid. Well, in today's world, one party could sue the other, and if there's no resolution, well, the case could be heard in front of a jury of your peers. But this was not always the case, and in fact wasn't the case back in colonial America. In fact, back then, such a dispute would have been held actually before the British Admiralty Court, if I can say that correctly. British Admiralty Court. No jury. Just a judge appointed by the Crown, who, if you lost, then yeah, you probably would have lost. Well, the judge would very likely receive a percentage of whatever was collected from you. Seems fair? No, it was not fair, and this was the very scenario that was common back in the day, and a scenario that terrified America's founders. And it's exactly why they wrote the Seventh Amendment. Now, the amendment itself sounds honestly almost comically simple, and that is, in suits at common law, where the value of controversy shall exceed $20, the right of trial by jury shall be preserved. $20. I mean, today that's, what, a couple of overpriced lattes and a muffin at Starbucks. But in 1791, for example, $20 was a lot of money. And here's what makes this amendment and this sort of fact pattern rather fascinating. The Seventh Amendment wasn't about criminal trials. The Sixth Amendment already covered those. This was, in fact, about civil disputes, so contracts, property, debts. The founders, well, they remembered how British officials manipulated civil courts to crush colonial businesses and silence political opponents. A merchant who, for example, criticized the Stamp Act, well, he might find himself suddenly sued for a massive set of damages in a court with no jury. Well, John Adams himself, the second president, well, he defended merchants in these courts, and he had watched the system destroy good and innocent people. And when Anti-Federalists read the new Constitution in 1787, well, they panicked. Where was the guarantee of civil juries? Patrick Henry, the man who is famous for saying, "Give me liberty or give me death." Well, he thundered in Virginia's ratifying convention and said that without civil juries, the new federal government could become as tyrannical as good old King George. Reality was that a judge could strip you of your property, your business, your livelihood. And James Madison, well, he originally thought that, a civil jury guarantee was unnecessary. Federal courts would, they'd naturally use juries, he argued, but the Anti-Federalists, thankfully, they wouldn't budge. States like Virginia and New York, they threatened to reject the Constitution entirely unless civil juries were guaranteed. Well, Madison eventually capitulated, and he included the protection in his draft of the Bill of Rights. Now, the $20 threshold actually sparked, believe it or not, fierce debate. Some wanted it higher, others lower. But they settled on $20 as a compromise. Such is life. Now today that $20 requirement still stands. It was never adjusted for inflation. It's a relic, a fossil from back in 1791, preserved in constitutional amber. But the principle it protects, I think, is vital. When the government or powerful interests drag you into court over money or property, you have the right to be judged by your fellow citizens, not just a single official in a robe who might have been, and likely was, appointed by, for example, the president, and perhaps was politically motivated. And by the way, if you've enjoyed this video, please consider liking the video and subscribing to the channel. Thanks.